Monday Ubani, thank you very much for your time.
Yeah, thank you for having me. Good evening.
How do legal experts view the constitutional and legal implications of the delay in establishing the credibility of the certificates presented by candidates for public office, high office that is, as highlighted in this particular case?
Well, of course, you follow the proceedings at the election tribunal at the appellate court, I mean at the court of appeal. The appeal court has given its judgment, and most of the things that they raised at that appeal court, at the appeal court was dismissed for lacking merit. Now, Atiku has proceeded further to the Supreme Court. Meanwhile, he sought for fresh evidence from the university that was attended by the president. And we follow the proceeding in America, where the court ordered that those records should be released, and those records were released 2 days ago. And so we will be watching the legal team of Atiku, what they want to do with the fresh evidence they have now gotten from the university. Whether they will now come by way of application for the admissibility of that evidence. And also we have to watch to know what they want to establish with that particular evidence they have gotten. Now, the first hurdle will be the admissibility of that document, or whatever they have gotten from the university. And now, if the court finds out that there were pleadings with the election petition averring the fact that there was forgery, then they were not able to produce this evidence during trial, but they have now succeeded in getting that evidence after the trial has been after the judgment has been given. The court will look at that particular fact as given by them in the application, supported by the affidavit, and then exercise what you call discretionary power, whether to admit or not to admit. In exercising that discretion, the law will be that it must be exercised judicially and judiciously and reasonably too. So if the court exercises discretion in favor of Atiku, well and fine. So he now proceeds with the second hurdle of what he wants to establish with evidence that has been admitted by the Supreme Court as the final court of the land. So it's not going to be very easy. So we'll watch all the proceedings and see what will come out of it. This is the first time a party in a electoral matter will go to the extent that has been done by Atiku. We know that there was an issue with a certificate of President Buhari. We know that story went forth and back, but we didn't get to this level where we have gotten with Tinubu's saga. This has taken a more international dimension, and it's really going to affect our politics, our jurisprudence, and even our electoral laws. Yes.
Some consider Atiku's, insistence to seek redress in the United States courts as some afterthoughts, since he could have done the same before the election was held. What's your take on this?
I don't have the full facts as to when this initiation for the records in American universities started. I don't know whether it was started after the judgment of the Court of Appeal or whether it was initiated when they were commencing the trial at the Court of Appeal. So I don't have that fact. But I know that there was allegation of forgery as part of their grounds of petition. Now, if they have alleged forgery, that forged document was part of it, I don't know whether it was at that point they initiated this process of getting this transcript, from the university, for which has actually they succeeded in getting yesterday and all that. So I don't have that fact, so I cannot be able to speak conclusively on that matter.
Monday Bani, considering the constitutional nature of the issue, what role can Nigeria's Supreme Court play in resolving the challenges related to the eligibility of candidates and the credibility of the certificates that they present? We also hear issues, questions surrounding whether this new evidence can be, presented as a fresh exhibit in the petition.
Yes. Yeah, the truth of the matter is that we are waiting the Supreme Court's position on this, but this is the final court in this electoral journey. The judiciary has a role to play. with regards to our electoral jurisprudence. By the time you conclude the result and result is announced, the next thing is that whoever feels aggrieved goes to the court. With the presidential election, it starts from the Court of Appeal, and the final court is the Supreme Court. So the Supreme Court will make the final pronouncement as to whether what the aggrieved party who has come to court is seeking for will be something that is realizable or something that lacks merit. So we need to really watch the Supreme Court, because this is really new. What I'm saying is this issue of bringing fresh, documentary evidence after you have concluded judgment. At the lower court. So we need to see what the Supreme Court will do with regards to that, establishing new precedent on electoral matter in admitting fresh evidence. And after that, what next? The grounds that they have posited at the lower court, as I said, it includes issue of forged document presented to INEC, is a ground for disqualification. How will the Supreme Court resolve this issue? The Supreme Court CJN the CJN of the Federation has said they will apply the law. They will look at the state of the law and apply law. They're not going to be bound by any sentiment, that they will look at law strictly and apply the law. So we watch and see how the Supreme Court will resolve this improperly at this point in time. I don't envy them. It's not an easy situation where elections have been concluded and somebody has been declared winner and even governance has started. And we're not going back on the issue of whether he was qualified with the issue of forged document to have been there in the first place and all that. So it's clearly very new and innovative, and something that all of us, will watch and see what will come out of it, from the Supreme Court of Nigeria.
Thank you, Mario. But in your opinion, to what extent does the delayed resolution of such issues affect the integrity of Nigeria's constitutional and election process?
I don't think that they have not followed the timeline as enshrined in the electoral law and the Constitution. The law says you have 180 days within which to resolve the issue at the court of first instance, and you have 60 days within which to resolve that. It's only electoral matters that have actually prescribed timeline. Other cases sometimes last 20 years and 30 years. We've been saying about it, but anything that has to do with politicians, and their issues, there is always a constant move to ensure that there is a speed in it. So you can see 180 days. And then now 60 days. So I don't think there is any delay. Everything is being resolved before December ending. All the issue that has to do with the election of 2023 would have come to an end. So I don't see any delay in it. They are working according to the timeline as prescribed by law.
All right, very quick one, Ubani. Such evidence, like you call it documentary evidence, from the United States legal system, like deposition, admissible in Nigerian courts?
Now, they have to follow the process. As I said earlier, it's a fresh evidence. The court has to look at the application and the supporting affidavit, why they should admit it.
Okay.
Now, it's going to be opposed.
All right.
It's going to be opposed by the opponent. I've said this before. So when the court now look at the affidavit evidence of the appellant and look at the counter affidavit of the respondent, it evaluates whatever they have said.
All right.
And then now exercises discretion. But as I said earlier, that discretion must be exercised judicially and judiciously. And of course, reasonably. It must be done with all the knowledge of the laws in the land, and then with fairness and equity in mind, and also to probably develop our jurisprudence. So at the end of the day, I just have this belief that the Supreme Court of Nigeria, with all the wise men and women that are there, with vast experience on jurisprudence and law, will be able to make a pronouncement that will be very befitting and satisfactory to all Nigerians. That is my belief. I don't have any doubt about that.
Thank you very much. We'll be watching to see how innovative the Supreme Court will be. We appreciate your time.
Thank you for having me.